Here to give us a better understanding of these leading topics is Robert Dunn of Counsel at the law firm Eimer Stahl. He's a former clerk for Supreme Court Justice Clarence Thomas and Justice Diarmuid O'Scanlan on the Ninth Circuit. He has litigated religious liberty cases for over a decade. He joins us from San Jose, California. Hi, Rob. Thank you for being with us today.
My pleasure, Montse. Good to be here.
Congratulations for your big Supreme Court win this week to protect Americans' rights to gather at home for worship. It was one of the most ridiculous rules that I've read about. Tell us about how the state of California was unnecessarily cracking down harder on religious activities than secular activities.
Yeah, so the gathering ban that we challenged in this case was egregious for a couple reasons. But as you know, California divides counties, into tiers. So there's purple tier where the virus is really running rampant, and then red, orange, and yellow. But the gathering guidance applied across all tiers, no indoor gatherings at all in a purple tier, and then after that, no more than 3 households. So if I wanted to host a Bible study in my house, for example, I couldn't have more than 2 other people over from different households, even if there were 0 cases of COVID in the county in which I lived. So it applied across the board. That was quite stark, and we recognized until the blueprint, what California calls the blueprint, is lifted, you will never be able to have a Bible study. And the blueprint has been in place for 10 months now. Newsom has finally, after this court decision, said that it may be lifted in June, but there's been no indication of when that would ever happen. So our clients who haven't been able to meet in home to have a Bible study, to have home-based worship, which is a really essential part of their faith, they have been banned from doing that for effectively a year, and there was no end in sight. So we challenged that rule, and what we pointed out is the state has allowed indoor restaurants, it's allowed indoor hair salons, it allows you to ride the bus with 10, 15 other people. You can gather in an airport with 100 people.
Right.
So there's all manner of sort of activities that the state finds valuable and that it has allowed to occur indoors. But indoor Bible studies was not something that the state thought was valuable, and so it didn't exempt it.
The government
and that's what we
here
challenge.
It's choosing winners and losers, right? Tell us a little bit about the importance of religious communities gathering in person and why that's so important for Christians, specifically your clients.
Yeah, so one of our clients is a pastor, and he put together a very, in my opinion, powerful declaration at the beginning of our case, laying out how critical it is for Christians to be together face to face. As he said, every description of the church in the Bible involves people gathering together, laying hands on each other to pray, being able to see one another and support one another. And technology is great. We're able to communicate right now, and I'm in San Jose and you're, back east, but that's not sufficient for, full-fledged Christian worship, especially not over the course of a year. You could maybe do that for a couple of weeks, and they voluntarily did. They didn't challenge the order right away. They, like everybody else, sort of did their part to try to slow the spread. But at some point, the governor has to recognize, and the state has to recognize, that religious gatherings are extremely important.
They're essential. That's right.
They're essential. They're essential. Yeah.
Let's change gears to talking about court packing. Democratic lawmakers introduced legislation to expand the Supreme Court to 13 justices. While House Speaker Nancy Pelosi shut it down, she did say that she supports the Biden administration's commission to analyze reforming the Supreme Court. What do you think the outcome of this will be?
Well, I suspect the outcome will be that they will not increase the number of the Supreme Court. I think cooler heads are going to prevail on that. It's riddled with problems. The first being, as soon as you say 13, Republicans get back in power, and it becomes 15 or 17 or 19. There's no stopping that train once you decide that 9 is no longer a fixed number, and whoever's in power can just alter it. So I think the Democrats have seen that has blown up in their face in the past when they destroyed the filibuster for lower court nominations, and I suspect they are not going to want to walk down that road again. And I think more fundamentally, Justice Breyer has even sort of come out forcefully and said this, as had Justice Ginsburg, that as soon as you introduce court packing, it becomes transparent that the court is just a political tool of the party in power. And once that is the case, the court lacks the essential credibility that it needs to do its job. Because as you know, Montse, the court doesn't have a police force. It doesn't pass laws. It doesn't have an army. All it has is its credibility. When it issues an opinion and, it expects parties to obey it, it expects the government, it expects state governments to obey what it says. it's the credibility of the court that sort of that compels them to do that. You know, there were calls immediately.
You brought up Justice Breyer. Yeah. That's exactly what he said. What about rumors of the demands for him to retire? What do you have to say about that?
Yeah, I mean, they did the same thing with Justice Ginsburg, and it's a decision that Justice Breyer will make on his own. He's not going to be pressured into it. I've met him. He's a delightful man. He's brilliant. And, you know, last I saw him, he was, you know, mentally sharp as a tack. So I don't have any reason to think that he's going to cave to that kind of pressure, but it's his decision. You know, he can decide to retire if he wants, but I think throwing pressure on him is going to be counterproductive. I just want to make one comment. Right after this opinion came out, there were several legal academics who urged California to ignore it. And I thought, wow, that's a sign of the times right there. You know, the governor is being pressured to ignore a Supreme Court decision.
That's right.
Because they thought, well, it's too political. And as soon as you start court packing, the pressure to do that is going to, you know, ramp up exponentially. You're going to have, you know, is Texas going to want to follow a Supreme Court decision that, you know, basically slaps down one of its laws?
That's right.
You know, you're going to have pressure from every corner, and that's just dangerous. At that point, you know, the Supreme Court has lost its legitimacy.
It becomes political rather than principled. Thank you so much, Rob. We hope you'll come back to discuss the Supreme Court again.